Okay, so today we're going to talk about, this is not the right slide. Oh, great. Okay, so today we're talking about the New York State out-of-network billing reform, which is effective April 1st, 2015, and so that's for services after April 1st, 2015. In the past, only HMO plans covered out-of-network emergency bills in full. No plans covered out-of-network surprise bills, and as a result, patients who went to out-of-network providers were responsible for expensive, unexpected, and unavoidable bills. We all remember those. We got more.
I read all those articles at times also.
So here's an example. This is something that probably all of you have seen. Under the old law, Mary's enrolled in a PPO. She goes to the emergency room and is seen by an on-call physician who's out-of-network. Her plan paid a percentage of the usual and customary rate for the service, but not the full amount for the physician's charge. She was left with a bill for $2,100. Mary doesn't understand why she's being asked to pay and wants to know how to dispute the bill, right? So that's one common example. Another one is John is enrolled in an EPO. He got knee surgery at a participating hospital with a participating surgeon, so he asked all the right questions, but the assistant surgeon was out of network. His plan paid nothing because he has no out-of-network benefits. He's being billed for the total amount, which is $9,500, right? So before, what did we used to do? We give advice to our clients that they could only dispute the plan's payment rate if they did not pay according to what the plan contract said they would pay. So we have a do-it-yourself packet for clients who wanted to dispute the reimbursement rate that their plan paid. They couldn't dispute the fact that they didn't have a chance to choose an in-network provider. And it was not for claims that was denied, it was for claims that were covered at the out-of-network rate, where the client believes the rate is too low. So it's usually for PPO and POS plans. The packet contains materials explaining to the client how to find out what the plan reimburses for out-of-network and how to check if the plan did so correctly. It also included a template letter. The template letter contained a footnote referencing the reimbursement rules for care received in the context of an emergency. So, you know, in the past or now for a service that's before April or after, before April 1st, we can still do these same things. When the plan denied services received in an emergency, we continue to use the ER packet. And we would explain to the client that appealing on these grounds is a long shot. They would be claiming that the plan covered the services but paid the wrong rate. And we can still use this same advice and the same packet for pre-April 2014 service. So we still get a couple of those calls. Okay, to address this issue, CSS and HIPAA engaged in advocacy and successfully partnered with CFS to implement new consumer protections, which was great. So what does the law do? The new law extends protections that were available only to HMO enrollees, PPO, EPO, and POS enrollees. It also creates a formal process for uninsured and self-insured consumers to dispute billing rates. Okay, so I'm going to go through all this stuff. It looks a little complicated, but and then I'm going to define everything. So basically, the patient receives a bill in an emergency.
Yeah, you don't have that. No, but it's here. I have this.
No, it's not the same.
Patient receives bill.
No, look at the
you're right.
Okay, carry on.
Sorry. Patient receives bill. If it's an emergency bill and they're fully insured, they're held harmless. They're self-insured, they go to IDR, which is independent dispute resolution. If they get a surprise bill and they're uninsured or self-insured, they go to IDR. And if they're fully insured, they're held harmless, right? So for the purposes of this law, it's really, really important to always find out if a client has a fully insured plan or a self-insured plan or if they're uninsured, because it really makes a difference on what their rights are. And I know this looks really complicated, but we're going to go break it down, okay?
What's the definition of the surprise bill?
Oh, you'll see.
Oh, will you?
Yeah, yeah. Okay, so what type of bill is it? This is the first thing we should find out. These protections only apply to out-of-network emergency bills and out-of-network surprise bills. Advocates should first determine whether the bill fits either of these definitions. And then we should find out what type of consumer it is. So there's different protections for fully insured, self-insured, or uninsured consumers, and so we should then determine what type of consumer it is. And this is just a review for everyone fully insured. The plan, the employer pays monthly premiums to an insurance company, and the insurance company assumes the risk of paying all healthcare costs. If an employee gets sick, the insurance company loses money. Common in smaller firms, 3 to 200 employees, and every QHP that we have in New York State, all the Medicaid managed care plans, those are all fully insured. They're subject to New York State law and federal law, and DFS has jurisdiction over these, right? For a self-insured plan, it's when the employer pays its employee's health care costs out of its own funds, but hires an insurance company to administer the plan. So if the employees get very sick, the employer loses money. It's common in larger firms, unions, or multi-state employers, and it's subject to federal law, and DFS has no jurisdiction, and that becomes relevant when I talk about later on. So generally, the advocate should contact the plan or HR to confirm what type of plan it is. Okay, what's IDR? IDR is Independent Dispute Resolution. It's regulated by DFS and administered by independent contractors. It allows self-insured and uninsured patients, providers, and health plans to dispute rates for out-of-network emergency services and out-of-network surprise bills. And IDR uses reviewers experienced in billing, usual and customary rates, and licensed physicians to determine the rate that will be paid to the provider. Okay. And the UCR is based on what Fair Health uses. Okay. So first we're going to cover emergency bills. Does anyone have any questions about what I just talked about here? So it's just a website. I think it's like fairhealth.org or something. I'm not sure. Yeah, but you can put in a CPT code and they'll tell you what the fair rate is, and it's based on
based in the area. And by the way, there's another website that does that. You read about that? I mentioned it to Alex and Alex.
Yeah, I saw that, but Fair Health is what the IDR uses, so that's a good place to start just for the purposes of these types of bills. Yeah. Okay, so first we're going to break down emergency bills. So the patient receives a bill. The bill meets the emergency services definition, which we'll go through. If they're self-insured or uninsured, they go to IDR and they pay a reasonable rate. If they're fully insured, they're held harmless. Okay? So what's an emergency service? Any services performed in the ER, including consultations from out-of-network providers ordered by an ER physician and performed in the ER, and ER services received outside of New York State. This doesn't include when you go to the ER and then you're admitted. The admission part is not part of the ER. So here's an example. Jean goes to the ER because of an in-network hospital because she has chest pain. She then receives a consultation from a cardiologist in the ER. Jean receives a bill for the out-of-network cardiologist. Is this an emergency bill? So yeah, the answer is yes. And if Jean was fully insured, these are her protections. So she's protected when she receives a bill for an out-of-network emergency service. She's to be held harmless for all out-of-network costs, but may have to pay in-network co-pays and co-insurance and deductibles. And how can she dispute? She should get a notice through an EOB from her insurance company that she's to be held harmless. If she keeps getting billed, the enrollee should contact the health plan and report the wrongful billing, right? So the health plan's provider relations should be able to reach out to the provider. These are some problems that we identified, right? So EOBs might not provide notice if the claimant is an emergency bill and then someone wouldn't know that they're supposed to be held harmless. If that happens, we should contact the health plan. If the health plan refuses to recognize a claim as an out-of-network emergency service bill, you can submit a formal complaint or try to do an internal appeal, to see if you could get them to recognize it as an emergency. The enrollee cannot initiate IDR because they're a fully insured plan and they don't have a right to IDR. And providers might be unwilling to hold enrollee harmless for the balance of the bill. So they should contact health plans provider relations. But the plan doesn't have a contract with the out-of-network doctor, so that might be difficult for them to get anywhere. And DFS doesn't have jurisdiction over providers and cannot force them to comply. Right? So you could just keep getting bills from the doctor. Out-of-network emergency bills protections are different for self-insured or uninsured patients. The patients are protected when they receive an excessive bill, and the law doesn't specify what's excessive, but ECR is used to determine a reasonable rate. And the bill is covered by IDR, and there's some CPT codes that aren't covered, but they're pretty specific, and we can look them up. How can the patient dispute the bills? They submit a complaint to IDR by filling out a patient application. And what is the patient responsible for? So the patient is responsible for an amount found reasonable by IDR. That means they still have to pay something, right? They still have to pay a bill. If that's the amount billed, so if they go to IDR and IDR says, actually, this was a reasonable amount, the patient is also responsible for a fee of $325 unless they qualify for a hardship waiver, which is under $250 at FPL. So I think they're trying to dissuade people from willy-nilly just filing for IDR.
So I think I'm confused.
Sure.
This is since April 1.
Mm-hmm.
So if you're in a self-insured, or uninsured, but self-insured, so you're not really protected.
Well,
because you can end up.
You're protected from excessive bills, but you're not protected from not knowing that you couldn't get that not choosing a network provider, for instance. So in the same way that fully insured plans, they're held harmless, here they're not, and the reason is because DFS doesn't have jurisdiction over these plans, right? So it can't make them do anything.
Yeah, that's why I was asking before that whether it's
yeah.
So you still can be totally insured, but you could be in a place
right.
where network and you have a problem and you just let them pay.
Yep.
And the self is often union, so we get a lot of calls on that from New York City employees.
Yep. Okay, so this is the IDR Emergency Services and Supplies Bill, like IDR application. It's on DFS's website. Here's an example for an uninsured or self-insured consumer. So Christina was in a car accident and sustained a serious head injury. She was rushed to the hospital. She just received a bill for all the services rendered at the ER. She is uninsured and can't afford to pay these bills. What should we do to help Christina? So we should check fairhealthconsumers.org to determine if the billed amount is reasonable. We determine her income level to see if she may qualify for a hardship waiver or if she can afford the IDR fee. If the amount billed appears unreasonable and Christina can afford the IDR fee or qualifies for a waiver, we can submit the application for IDR. Or if she doesn't want to go through the trouble, she can also advise Christina that she may qualify for hospital financial assistance. Okay. And we should always remind clients that if they're over $250 and they lose, they have to pay the rate that's on the bill plus $325, right? So something like charity care might be better for them.
Mm-hmm. So it sounds like you should recommend that people don't.
Depending on how unreasonable, well, it depends on how excessive the bill is, right? If the bill is like crazy excessive, then charity care, might not be a better option. IDR might be a better option, but it really just depends on the situation. But regardless, we should advise clients of all their rights, right? We should tell them exactly what they have the right to, and so that's part of it. Okay, so these are some potential problems. The patient, especially on an uninsured plan, will not receive notice of the protections. Like, how would they even know that they could get IDR, right? Because they don't get an EOB. The billed rate might be reasonable, and the patient will then be responsible for the IDR fee. And DFS just doesn't have jurisdiction over providers or self-insured plans, so there might be enforcement issues. Okay. Does anyone have any questions about emergencies?
I find this is all very good and helpful, but there's a lot of information, and I need to digest this. Are you going to get renumber these? These are like.
So I'm going to reprint them, so I will print you the correct set of slides.
I was going to say this is dense.
Yeah, and we also put together some one-pagers that'll be on the portal that will say, like, step 1, ask the consumer this. Step 2, ask the consumer this. So those will be really helpful.
I think these roadmaps are often great, but you've been going through them, and it's like I'm dying to just sit down and
Sure.
go through it. I'm hoping that this will be.
Yeah, and I mean, the material is hard, and even for me, you know, I have to remind myself which one is which all the time. So when you have the one pages, it makes it a bit easier.
I'm glad you said that because I was feeling stupid.
No, it took me months to understand this. Okay, so now we're going to talk about surprise bills. So the patient receives a bill. If they're uninsured or self-insured, it goes to IDR, and they pay the reasonable rate. If they're fully insured, they submit an assignment of benefits form, and they're held harmless. All right, so the two big things to remember is that a self-insured or uninsured person will always go to IDR, and the surprise bill or the fully insured person will always be held harmless, but there are different ways to get there.
So again, what's the surprise? Because it's out, you tell me more.
Oh, I'm going to tell you more. So eager. Hey, what is a surprise bill for fully insured enrollees?
I love the picture.
Yeah. Okay, so an enrollee receives a non-emergency service at an in-network hospital or ambulatory service, sorry, Kevin's face cut that off, and an in-network physician was unavailable, or an out-of-network physician treated the patient without his or her knowledge, or an enrollee was not given an opportunity to choose an in-network physician, okay? Or they go to a doctor's office, an in-network provider's office, and the out-of-network physician treated the patient. The in-network provider used an out-of-network laboratory or pathologist, so that one we see all the time, right? Or the in-network provider gave a referral to an out-of-network service or provider, okay? So here's an example. Ted was scheduled to receive hip surgery at an in-network hospital with an in-network physician. Ted received a bill from an out-of-network anesthesiologist for the surgery. Is this a surprise bill? So this is our classic example, right? So how do we identify it? Was Ted fully insured? Yes. Was Ted told that anesthesiologist was out of network? No. Was Ted given an opportunity to choose an in-network anesthesiologist? No. So it's a surprise bill. Okay? So these are the protections.
And what about, I was interested when you said if you go to an in-network doctor and he tells you to go see another doctor, he gives you a prescription. But it never says it has to be this other doctor.
I mean, if it's a formal referral, then it counts. But if he says, here's a number of doctors and, you know, pick one, then
what's a formal referral?
like a referral that's written down on a...
It must be Dr.
Yeah.
HMO, yeah.
Or like to send you to the wrong lab. And it's not your responsibility then to check.
No. Right. But you have to be, the doctor that you're seeing has to be your, you know, in-network physician. Okay, so what's the enrollee responsible for? They're held harmless and only responsible for in-network co-pays, co-insurance, and deductibles. Again, this is just for fully insured plans. How does the enrollee know they have received a surprise bill? So the EOB stating a claim should say that it's a surprise bill and provide the directions on how to access and assign.
Really? Wow.
Yeah, and we've seen it.
I want to see what that looks like.
Yeah, we've seen those. They've actually been putting them on the EOB.
And people read that and say, what the hell are they talking about? Because most people have no idea what this law is.
Right.
They know it's a surprise.
Yeah.
Okay, so how does the enrollee dispute the bill? This one is different for surprise bills than it is for ER. So the enrollee must complete an assignment of benefits form. It's available on the DFS website, and they submit it to the provider and health plan with the disputed bill. If the provider continues to bill the enrollee thereafter, they should contact provider relations at the health plan. So in the emergencies, they don't have to fill out this assignment of benefits form, but in the surprise bills, they do. This is the assignment of benefits form available on the DFS website. So here's some potential problems. EOBs might not provide notice that a claim might be a surprise bill. So far, we've been seeing them. If this happens, advocates should try to contact the health plan. And if the plan refuses to recognize the claim as a surprise bill, you can submit a formal complaint. The enrollee, again, cannot initiate IDR because it's a fully insured plan. And providers may be unwilling to hold the enrollee harmless with a balance. They should attempt to contact the health plan's provider relations, but again, DFS does not have jurisdiction over providers and cannot force them to comply. So it's the same sort of issues. So for self-insured and uninsured patients, there's different definitions of what a surprise bill is, okay? The physician's office fails to disclose the plans they participate in, the hospitals are affiliated with, the cost of the service, or the contact information of providers they refer. Or they go to a hospital to get non-emergency care, and the hospital fails to disclose on their website the charges, statement that physician services provided at the hospital are not included in hospital charges and might be out of network, the contact information of physicians and contact information of physicians and plan participation of physicians. They also have to give you this information, disclose the information in the registration materials, right? So there should be an advisory to contact the physician arranging services to determine who else is scheduled to provide services and their contact information, right? So if you're going in for surgery, you should get a list of all the doctors that are going to be seeing you and what plans they take, and directions how to find what plans physicians are contracted with and employed by the hospital.
So hospitals are doing this?
We're not sure yet. It's also new. We haven't really seen. Okay. So surprise bills for insured and uninsured and self-insured patients. The patient is protected when the service is not exempt from IDR, if the billed amount is excessive and the provider fails to make a mandatory disclosure. The client disputes the bill by filling out an application for IDR and submitting it to DFS. And again, they're responsible for the amount found reasonable. If it's the billed amount, they'll also be responsible for the IDR fee unless they qualify for a waiver, right? Here's an example. Emily Clark, goes to a doctor in the neighborhood for a blood test. The doctor's office does not tell her which plans they take. Emily receives a bill because the provider does not accept her plans. How should we advise Emily? Was Emily self-insured? Yes. Did the provider's office disclose which plans they accept? No. So it is a surprise bill. So Emily should complete a patient application for IDR and submit it to DFS, and she'll be responsible for the amount found reasonable, et cetera, et cetera. Here's an uninsured person. Jim is uninsured. He goes to a private provider for a checkup. In the course of the checkup, the provider finds a lump and does a battery of tests. Jim gets a bill for $10,000 and is not eligible for charity care because he goes to a private provider. How should we advise Jim? So was the bill excessive? Maybe. We should check Fair Health to see if the amount billed was a reasonable rate. If it was excessive, Jim can complete a patient application for IDR. He's responsible for the amount found reasonable. And as an alternative, we could also advise Jim that he can negotiate with the provider.
Sorry, are there timelines to do an IDR just like there are timelines to do an appeal?
You know what? Probably, but I'm not sure. But I can check and find out. Okay. I'll let people know.
You said if he was uninsured, he couldn't apply for charity?
In this, he could if it was a hospital, but he can't apply for charity care with a private doctor.
Oh, not with a doctor.
Yeah, so that was the scenario.
Got it.
Yeah. But yes, if he's at a hospital.
Yeah, then he can. Yeah. That's what it's for.
So here are some potential problems. Patient might not have notice of the protection. The billed rate might be reasonable, and the patient will then be responsible for the IDR fee. This one is a big one for me. For verbal disclosures, how do you prove that the provider didn't disclose the information? There's no language on burden of proof and who has the burden of proof. And DFS doesn't have jurisdiction over providers or self-insured plans, and so there might be enforcement issues. Okay. Does anyone have any questions about surprise bills before I move on?
I just think it's asking the client to figure out a lot of stuff, and the whole system is so hard to figure out in the first place. It's better to have it than not have it, but who would have a clue of what this is about?
Yeah. What happens after a claim is submitted for a self-insured or uninsured client? So the patient or provider submits a claim, the health plan negotiates, the health plan pays less than the billed amount, and then you can go to IDR. Right? So the health plan must so if the claim, what the health plan must do. So if the claim is for an emergency or for a surprise bill submitted with an assignment of benefits form, then they have to negotiate and promptly pay the provider. If the negotiations fail, then the health plan decides to pay less than the amount billed, provide the enrollee with an EOB saying the enrollee is only responsible for in-network cost sharing. So that's for a fully insured plan. The amount of the plan paid to the provider may increase if an IDR entity finds the reimbursement rate to be unreasonable. That's for a self-insured or uninsured person. And the enrollee should contact the plan in the event they are balance billed. That's again for fully insured. We should switch those around. And the health plan must tell the provider how to initiate IDR. So that would be in an EOB.
Oh, okay.
So IDR for providers and health plans. The health plan or provider can initiate the IDR process by submitting a complaint to DFS. Some bills are exempt from IDR. However, fully insured enrollees still must be held harmless for those bills. Providers may only bill enrollees for applicable in-network cost sharing. That's for a fully insured plan. When a dispute is eligible for IDR, the health plan or provider will be responsible for the amount IDR finds reasonable, and you can contact the health plan to complain about the balance billing and DFS to complain about the health plan or the process. Questions? Sorry, I know it's a lot of information, but I think the one-pagers will help, we need it away.
Bullet points.
Yeah.
Also, when we thought about doing with the Monday group, because I felt like this a lot is great, but still not able to digest it all together. So next month, when we do
The Health Insurance Portability and Accountability Act of 1996. Let me move this.
You can,
Okay.
right.
Yeah. Okay, so many of you are familiar with HIPAA. You regularly follow the directives from HIPAA, and so this is an overview of many of the policies and procedures that we're already enacting here at CSS, and just to give a greater overview of the scope of the law and how we also use it in practice. And so all of our health initiative programs have to comply with HIPAA. And, you know, the point of complying with HIPAA is to protect the integrity and confidentiality of health and other sensitive information pertaining to clients. So we'll go over an overview first. Individually identifiable health information is sensitive and confidential. Of course, we all know that. And so HIPAA protects its improper use and disclosure. It also creates certain rights of access to information for our clients and other parties. And so we'll go over that in more detail, but clients do have certain information and a right to access their information. And then, you know, disclosures do may harm the client. They can also harm our department, Health Initiatives Department, and the staff. And so we have to take measures to ensure that access to protected health information is limited so that we minimize the risk of unauthorized disclosure. So a lot of this is, you know, risk management and avoiding potential breaches of HIPAA. And HIPAA operates on a need-to-know basis of access. So there's a minimum standard whereby we only share and access the minimum that we need in order to perform our duties. So HIPAA has two parts. It has a privacy rule, which we're all familiar with. It also defines what clients can do with their information that we have, and it specifies authorized uses and disclosures. Then the second rule is the security rule, and it creates certain criteria and rules around the administration of programs that deal with protected health information. And it goes as far as to specify documentation requirements to comply with HIPAA. And then HITECH deals with the health information technology, and it's we won't really go into too much detail for this training purpose for that. So we'll just go over some general definitions. Individually identifiable health information is information including clinical, financial, demographic, and lifestyle information collected from or about an individual that is created or received by a healthcare provider, health plan, employer, or healthcare clearinghouse, and relates to the past, present, or future physical or mental health or condition of an individual, the provision of health care to an individual, or the past, present, or future payment for the provision of health care to an individual that identifies the individual, or with respect to where there's a reasonable basis to believe the information can be used to identify the individual. So that was a lot of reading, but essentially you can
see here that this individually identifiable health information is the stuff that we get on the helpline all the time. You know, we're getting, through our intake forms, we're getting information about the individual, their health care concerns, information about their health insurance. All of the information that we need to assist clients falls within this category of individually identifiable health information. So then protected health information, which we often refer to as PHI, is individually identifiable health information that is transmitted by electronic media, maintained in electronic media, or transmitted or maintained in any other form or medium, including paper, electronic, and oral information. Then there's also EPHI, which is protected health information that's transmitted by electronic media or maintained in electronic media. A privacy officer is a designated representative from each of the health initiative programs who's responsible for ensuring compliance with the HIPAA privacy rule. Prior to this, it was Diane, and so my understanding is moving forward, there'll be a point person for each program, and we will make sure that all of the volunteers know to whom they can go to in the event that they have a question or concern regarding HIPAA.
So that person for art
So you can always reach out to a helpline supervisor, which is, you know, is between the two of us, and then if it's Priscilla, you can always come to my office and we'll all work together to deal with any HIPAA-related issues. So the definition of workforce for the purpose of the HIPAA training includes employees, volunteers, trainees, students, and other persons whose conduct in the performance of work for health initiatives is under the direct control of health initiatives, whether or not they're paid by health initiatives, including volunteers. So HIPAA protects the client's information that is clinical, financial, lifestyle-related, or demographic. So just to drill a little bit more into the definition of protected health information, some of the identifiers that would be included under that category are names, you know, geographical subdivision smaller than the state, so county, city, borough, all elements of dates for dates directly related to an individual, so birth dates, admissions date, discharge date, date of death, and all ages over 89.
What does that mean?
I don't know exactly why, but my guess would be that it's a smaller population, so that if you have all the ages over that age plus a name or something, you can piece together more easily that individual. That would be my guess, but that's purely a guess.
I don't think we have too many people over 89 polling.
I can double check that, but that's my guess. In addition, phone numbers and fax numbers, emails, social security numbers, medical records, health plan, account numbers, or certificate and license numbers. So essentially, these types of pieces of information that you could use to identify a person. How does HIPAA apply to volunteers? So we train all volunteers on HIPAA. This training is one of them, and we do ongoing HIPAA trainings, I believe, as the need arises or changes occur. The same for staff. We go through HIPAA training as well. Everyone must follow HIPAA policies and procedures, and we all must take action when you suspect or detect a breach, which, as I mentioned, you can bring to the helpline supervisor and or myself. So this is just an overview of some of the policies that we as an organization have created to comply with HIPAA. We have policies regarding who can access information, who establishes these policies, how they're modified, and when and if these policies are terminated. We have a destruction policy, which I believe includes in a small part that we are shredding all of these documents, and you know that we have the, I guess they're called cross-stitch shredders where it's not the single line ones. It's not just the strips, so we're not having anyone piece together things from the we also have a social media and networking policy, a workstation use policy, work at home and use of documents on transportation, a fax policy, HIPAA email policy, password policy, and notice of privacy practices, and we will break these all down. So the access authorization, establishment, modification, and termination policy, in addition to being a mouthful, means that volunteers will be given access to PHI or ePHI, which is electronic protected health information, that they have a specific need for access to and will receive only the minimum access necessary to perform their duties, limited to necessary tasks. So that means if you are working directly with client information, that the expectation and the policy is that we only access, that specific information that for the clients that you've been assigned to or that you're helping. I think Diane said we're not, cruising the database for different information. It's what you need to know in order to assist a specific client that's called you. And those access parameters are determined by the supervisors, and we work with the IT department, and we can modify them as needed. So the destruction policy means that we're destroying data that no longer needs to be retained. So every day I know that you shred your intake sheets, any duplicate printouts that you have of client information, you're shredding. If you save client documents in a shared folder on the computer, we're removing them from the shared folder, deleting them and sharing them, putting them in a specific client folder that's protected through limited access to individuals who have access to that client folder. And if you ever have any questions about documents and what you should be doing, then please check in with the helpline.
Okay, so where do the documents go when we ask people to send us documents by email?
Those go to a central. Yeah, they go to a central. They go to Mariah has access to that chat email address. She's the only one who logs into it, and so they only go to her, and then she distributes them as they're needed to the case handler who's assigned to the matter. And so they're not coming in.
They're all online. You know what I mean? In the file called client documents, they're all there.
They are? I didn't know that.
So all the folders on the drive are limited, so people who are in the organization who are not members of community health advocates cannot even get into that folder. And so we're also working now on further restricting access for certain folders, and so that may be something that comes up in the next couple of weeks, that you'll see some changes as to where certain folders are and access to those folders. But the idea is that they go through Mariah into a central email that she checks.
And that's why she's the only one who's allowed to get certain things.
Correct.
So when the case is closed, do they live forever online somewhere? I mean, they're not destroyed, they're online.
You mean the client documents?
Yeah, that's a good question. They're still there.
They're there forever.
Documents there from 3 years ago.
So that's something we should I'll check about, and make sure that, the folders are being regularly.
Yeah. What happens is that we can really delete them because the program is going. Clients, we get repeat clients. So
and you need
the
them.
actual file that the case handler has, once the case is closed, goes to archives. But the electronic version is kept, because in the past we used to delete everything, and then the client.
And then you had to do the whole thing over again.
That I sent you these documents already.
Got it.
Okay. So that's why they're stored there.
Yeah, well, wait, you're not, anyway, Kristen, you're not deleting. You need these for record keeping and for monitoring.
Right, after, many years.
We have this competing interest, right, where we need to protect HIPAA-related protected health information, but we also need to save client records, I think, for a minimum of 7 years.
7 years, the magic number.
So the idea is to, maintain these records, but maintain them in a secure location where only those who need to access information are accessing it.
That makes sense, because hospitals have all our stuff, lots of stuff.
And by the way, the physical records we keep, even though we don't print as much, we get the faxes, we get everything, and we're not exactly taking everything home with us and like guarding it night and day, every single thing we get here.
Yeah, we're leaving it,
we're
leaving it in the office.
Staff walking in and out, and you know what I mean. But anyway, I'm not going to go there.
Yeah.
We do email policy yet.
Not yet. No, we're on to social media and networking. So the use of social networks puts confidential, financial, and other health information at risk for a breach of confidentiality or other harm. So Health Initiatives reserves the right to monitor and instruct staff or volunteers from the use of social media and networking. My understanding is that many of these websites, you know, Facebook, Twitter, they're blocked anyways on the computers while people are on duty. And the expectation is that, you know, volunteers and staff are not discussing any CSS health initiatives related information or client topics, you know, on social media, whether you're on or off duty. And there's a general prohibition from posting any content that, you know, contains personally individual identifiable health information. So I think the classic example is someone who's had an issue at work, has a difficult client, and decides to tell their 500 friends on Facebook all about it. And stupid. It happens, you know. Yeah, it's happened a lot. People have been fired from, I think, prominent positions.
Oh, yeah.
I mean, it's, you know.
You hear about that all the time. Or don't get jobs because they were angry at their boss and told 500,000 friends.
Yeah. I think it's safer to tell your therapist.
Yes.
We're under HIPAA rules. Yes. So we also have a workstation use policy. You know, we all know that things happen, you know, things that are kept on the workstation are vulnerable to water, fire, power surges, and, you know, curious eyes who are walking by. So to minimize potential damaging of protected health information or whatever other issues would arise related to this, the idea is to limit eating and drinking when possible. You know, it's very hard to do here, but you can see, you know, the Coke bottles spilling all over the place, and it happens. So we have busy lives. I am a desk eater. I am guilty of that. But to the extent possible, that is our workstation use policy. I think you don't see Priscilla and I going around, you know, yelling at people about it. But we have policies. We also, you know, to me, I think perhaps more importantly, you take reasonable steps to ensure the confidentiality of your passwords. You know, we don't put our Post-it notes with all our lists of our passwords on the monitor. We don't leave our printers unattended, so, you know, we like to go grab our stuff that comes out from the printer right away so there's not protected health information hanging out at a public space. We ask that volunteers don't solicit outside business, engage in political, religious, or charity activity while at their workstations.
There's an election coming up?
No, I know my joke yesterday was, please do your, you know, fundraising for Trump on your no downloading or transporting of data and no uploading of software. We know that these things are, you know, prone to getting bugs. There's malware. There's the Trojan horses where you download something that you think is this innocuous app and it actually records all your keystrokes, which could then, you know, if you're typing in information on the database, potentially that could be extracted, and that's a HIPAA breach. So if you are wanting to download or upload anything, please run it by the helpline supervisor, and then we'll run it by IT.
That's all fine, but I'm sorry to be, you know, beat a dead horse, but I don't understand why eating and drinking has anything to do with HIPAA. I understand that it could harm the workstation, but why is it on the HIPAA list?
Yeah, that's a true good point.
It doesn't matter. She had to get it in there, that's why.
Yeah, I don't know. Maybe if you spill soda on a computer, it's like the Pop Rocks thing that your body will explode. So maybe if you spill soda on the computer, like everything that's contained within it is sent out into the internet. I don't know.
That would be a quick way to get things out.
Yeah, maybe. I think, you know what, the idea, or because the idea is not only that it could be a breach, it's the potential destruction of protected health information, which we then would not be able to access to do our job. So if you save something, you know, again, I'm guessing, yeah. If you save something on the desktop and then you destroy a computer. Okay. So,
Don't drop any coke on anything.
transportation and work at home policy. So staff are prohibited from doing this as well. We're not allowed to transport any electronic or paper form of any client protected health information. Everything that we do on the CHA cases here is done during business hours at our office location only, and we don't work from home. We don't want to add to your plates. We're very grateful that you do come in weekly and, you know, volunteer with us. We wouldn't want to create any greater burden on you, separate and apart from the HIPAA issues that arise out of taking work home. So our fax policy is that we use an e-fax system for new and existing client documents. So when we give that fax number out to clients to send their documents in, it doesn't get spit out from a fax machine. It goes to the e-fax, which gets routed to Mariah's email, and so that eliminates the potential for inadvertent disclosure, misdirected, or lost documents. So then the use of the fax, if it contains medical records, should be limited and used only if there's no other means available. So if you need to send medical records or protected health information outside of CSS, you should check with the helpline supervisor. If you send a fax and you get a digit wrong and it's sent to a third party to whom you didn't mean to send it, please let the helpline supervisor know. And then our administrative staff makes checks of the fax system area, the fax actual physical fax, so that when we have outgoing faxes, people aren't leaving documents. There's, you know, the confirmation sheet gets spit out after you send, and so there's information there. So we're making sure that none of those types of documents are lying around. And in, you know, for example, if there's an issue with the e-fax and the faxes are coming out of the fax machine, we have admin staff to check that.
So what is the email policy? What optimum? What do you prefer? What would you like us to do when we need to send information to a client? Use fax, use email, use hard mail?
So it depends. If you're sending information to a client, the likelihood is that it's probably general information. We're sending do-it-yourself packets, you know.
No, I don't mean that. I mean specifically, which brings me to the email policy. I mean sending them information, PHI.
Well, we would send you an example.
That's the acronym we've been using, right? PHI, Personal Health.
Mm-hmm.
Okay.
Yeah.
Last week with the client in Czechoslovakia, there were some forms that mentioned her specific case.
So I think it's on a case-by-case basis, because all of the communication that goes out through the helpline has to be screened by the supervisor anyways. Yeah, that's what you do anyways. And so I think the idea with that slide is that, you know, fax may not be the optimum way. And so now I think the answer to your question is here.
I've never done that here, and I'm happy to learn if you're going to give us the ability to do passwords. Tell me how to do it. Okay.
So let's, I think this will in part answer your question, and then we can, you know, discuss in further detail any specific cases. Health initiative emails are property of Community Service Society. CSS reserves the right to audit, delete, monitor, and read emails of staff and volunteers. It's for, you know, quality assurance purposes, for administrative purposes. As someone who used to practice employment law, I am shocked by the things that people put in their work emails and expect privacy for them. And so just know that everything there should be no expectation of privacy for anything that comes in and out of the server here at CSS. And so with that in mind, everything on the CSS email should be restricted to business or administrative purposes. Again, no personal use, business activity, solicitation, organization, or political campaigns. Please don't send out, email blasts for your latest pep rally, for whatever candidate through CSS email. If you're emailing documents for protected health information, they should be password protected. I imagine that will involve more one-on-one situations. And then if you have a doubt as to whether or not something has PHI and you're emailing it, just run it by us and we'll deal with it on a case-by-case basis. And we shouldn't be forwarding client emails outside of health initiative email. So even if you want to remind yourself about something next week, you shouldn't be emailing it to your Gmail or other email. It has to stay within CSS email.
Now, I once tried to get to the portal when I was at home because I wanted to see these packets that we sent out. Can't do it.
Yeah.
And I just wanted to look at, stuff that's certainly not PHI, and I just couldn't.
Yeah, it's access is restricted to here. Yeah. So just talking about these HIPAA regulations and policies and procedures and how it applies to you as a volunteer. The idea is to stick to the minimum necessary standard, and again, that is sharing information and gathering information to the extent that's necessary for you to do your job as a volunteer. And sometimes that means sharing certain information with the helpline supervisor. Volunteers bounce ideas back and forth if they need further assistance, but it shouldn't go as far as, discussing outside of the context of assisting a client case information, protected health information of clients. It should be on a need-to-know basis. Also requires keeping documents secure, leaving them with the helpline supervisor at the end of the day, shredding your intake sheets, any other documents that you've made notes that contain client information on them, shredding them at the end of the day. Being careful with the computer, so logging out if you're leaving for the day or if you'll be away from your desk for more than 10 minutes. Only discuss cases with staff while you're at CSS, so if you run into me at the subway, like, let's talk about the weather or other fun things. No one wants to be talking about work stuff outside of work anyways. Don't use USBs or, transfer information to laptops or your cell phone or record any, CSS-related information about clients on those personal devices. Don't access chat or the enrollment-based database from home or outside of CSS, and leave any follow-up to the helpline supervisor unless you're asked to do so on the next shift, or some of you have clients that you've worked with that you've established a relationship with, and you will plan to follow up with them on the next shift. Just let the helpline supervisor know so that we have an understanding and we're not marking it for follow-up for someone else, or the client gets a call from someone who doesn't know that that client's expecting a call from you. So just keep open lines of communication regarding that. So one new thing that's coming down the pipeline for us is in order to comply with HIPAA, we have to share our notice of privacy practices with callers. So we're uploading that document to the portal. It is a several-page long document that notifies consumers of their privacy rights, includes information on how we may or use or disclose their health information, information about how they can complain if they believe that we've violated their rights, and informs consumers of our responsibility to protect consumer health information. So we're in the process of updating the intake sheet because clients will need to be notified about the availability of this notice. And also, I think Priscilla might mention this too, there is you may have encountered this already, for example, with a doctor's office, but when your client is giving you contact information, they have to be offered an alternate form of communication. So if they don't wish to be called, for example, should we email them or should we mail them things? If we call, is it okay to leave a voicemail? Can we identify ourselves as community health advocates? You know, things of that nature where the caller is then in control of their our contact with them and has some control over, you know, our description of who we are and
So how are we going to get this across to the client? How are we going to?
we're going to have
on it. Yeah.
We're going to have some script language.
You say, is it all right if I call you and you're not there? Is it all right if I leave a voicemail?
Right.
And is it okay if I say?
Yeah, but we have to write all. That's a lot of stuff that we're going to have to say that we didn't do. Because in a hospital setting, they just, you know, that's just give it out to people. That's it. But we'll have to say it because we do everything by telephone.
Because we're doing everything by telephone, yeah. So it will, you know, our goal would be to make it as, you know, not as least cumbersome as possible, but then we also want to comply with HIPAA. So we're reworking the intake sheets now, and we'll be introducing them in the next several weeks. So the document will be located on the portal. So if a client or a caller says, actually, I would like to see the notice of privacy practices, we can email them. HIPAA law, though, requires that if the client requests a paper copy, we mail them out. You know, it may be that many clients are happy finding it on, we'll also, I think, have it in a public location on the Community Health Advocates website, so they could go online and check it themselves. We could email it to them. If someone really wants it and wants a paper copy, we just mail it to them.
So we're going to have to go through that before we get into whatever they're calling about?
Awkward. People are very, you know, emotional when they call. They're not going to want to hear that. Maybe at the end.
I mean, what
how are you going to say?
I don't think it has to be the initial
Yeah,
in
I
the
don't
front.
think, you know, like, it's going to be part of the intake form. I would say that that's part of the wrap-up process. Like, once you have established, like,
At the end.
what's the client's needs, like, you have the contact information, and, like, we're talking about next steps, that's, I think, when you would like to introduce that. Like,
yeah, at the end.
Sometimes the client is very emotional, and they're just anxious to get it all out, and then I'm talking about notice of privacy practices.
Yeah, it's going to turn them on.
Yeah.
Barbara, I think, like, you know, you're experienced enough. I know you are. You know, I think everyone here is. You know how you just get a sense of how.
Yeah, we're the person.
You know what I mean? How it's
No, I
starting.
understand.
And
I
you'll know
understand
that, but the question is what's going to be the rules,
Mm-hmm.
what you want to.
You have to get it across that you have to do it a way that makes sense.
Yeah.
Yeah, I think for me, in most circumstances, it would probably be, the goal is to have a conversation where you get the necessary intake information and get a picture of what the story is so that you can provide advice or at least complete this intake to the degree that a case handler can then take it over. And maybe what I would probably do is, you know, when you're wrapping up, say, you know, I should advise you that we have a notice of privacy practice on the website that you can access, or I can mail you a copy. I think at this point people may have heard this in another context before, or seen them when they go to the hospital.
So in the hospital, because they're calling because they have a medical issue.
Yeah. So I think if you can work it in the most natural way, that you can start bringing up notice of privacy practices. But certainly, it would be more awkward in the beginning of the conversation. Let's talk about HIPAA breaches. There's a definition, which I'll read. The unauthorized acquisition, access, use, or disclosure of PI that compromises the security, privacy, or integrity of protected health information. To put that in example form, a breach would be violating a HIPAA policy whether or not it results in harm to a client. So the breach can occur whether or not ultimately the client is harmed. If you, for concrete example, leaving paper records on the subway that are not in a locked container, writing your password on a Post-it note and leaving it at the computer, which I mentioned earlier, and talking about clients outside with your friends or family. Oh, that's it. I didn't know we were so close to the end. Let me pause. I will take any more specific questions.